Be ready for the dictation. 5, 4, 3, 2, 1. Start. This was followed by two declarations published by the state under Section 6 of the Act. One was published on 31st May 2005. It was in relation to first notification issued under Section 4 of the Act on 11th January 2005, whereas other declaration was published on 8th February 2006. It was in relation to second notification issued under Section 4 of the Act on 17th November 2005. This was followed by the initiation of the proceedings for determination of compensation payable by the state to the landowners whose lands were acquired in the acquisition proceedings in question. Notices to landowners were accordingly issued under Section 9 of the Act. The Land Acquisition Officer held an inquiry as required under Section 11 of the Act and passed separate awards in relation to the lands situated in different villages on 10th May 2006. The Land Acquisition Officer determined the uniform rate applicable to entire acquired land payable to every landowner. In his opinion, all the landowners whose lands were acquired in the aforementioned villages were entitled to get the compensation at the uniform rate. Dissatisfied with the awards, the landowners filed their objections under Section 18 of the Act 13 and prayed for making reference to the civil court for fresh determination of the compensation and the rate at which it was payable. As a consequence thereof, land references were accordingly made and forwarded to the reference court for redetermination of the compensation under the Act. As many as 41 land references were made to the reference court. By a common award dated 27 February 2012, the reference court, civil court, partly allowed all the reference cases and enhanced the rate of compensation at Rs 43 lakhs per acre. In other words, the reference court enhanced the rate. This determination gave rise to filing of first appeals by the landowners as well as the state of Haryana in the High Court of Punjab and Haryana under Section 54 of the Act. As stated at the bar, in 14 all, 556 first appeals were filed in the High Court against the award of the reference court, out of which 258 appeals were filed by the landowners and remaining 298 appeals by the state. So far as the appeals filed by the landowners were concerned, the landowners prayed therein for grant of more compensation than what was awarded by the reference court. In other words, the case of the landowners in the High Court in support of their appeals was that the reference court though was right in enhancing the rate of compensation, but was not right in awarding at the rate of Rs 43 lakhs per acre. According to them, the rate of land determined by the reference court should have been much higher than Rs 43 lakhs per acre because the acquired land had immense potential. So far as the appeals filed by the state were concerned, the case of the state in the appeals was that the reference court erred in determining the market rate of the land at the rate of Rs 43 lakhs per acre. According to the state, it was on higher side as compared to what was fixed Rs 43 lakhs per acre, which, in the facts and circumstances of the case, was just, proper and adequate with no scope of any further enhancement therein. By impugned judgment, the High Court partly allowed the appeals filed by the landowners and as a consequence thereof dismissed the appeals filed by the state. The High Court, while partly allowing the landowners' appeals, further enhanced the rate of acquired land. In other words, in the opinion of the High Court, the fair market rate of acquired land should be at Rs 60 lakhs per acre and, therefore, the compensation be paid to each landowner for their acquired lands. Against this judgment of the High Court, the landowners as well as the state both felt aggrieved and filed these appeals by way of special leave in this court.